Hello, good morning and welcome to today's News on the Block Knowledge Bank session entitled Service Charges and the First Tier Tribunal. This session is brought to you by our expert Cassandra Zanelli, Solicitor and CEO of Property Management Legal Services Limited. She is also a member of the ARMA Advisory Panel, working closely as a course tutor and an honorary consultant to the FPRA, so well placed to help you today. Questions will be answered throughout the session, so if you've got any questions at any time, please pop them in the Q&A right at the bottom in the middle of the screen. I will hand you straight over now to Cassandra. Good morning, Cassandra.
Morning, how are you?
Very well, thank you, and you?
Not bad for a cold Thursday morning.
Chilly.
It is, I've put the heating on, it's cold this morning. My husband will shout at me later for putting the heating on quite so early. Morning everybody, I hope everybody is staying safe and well and that you're all getting ready for Christmas. Hopefully you're all joining us for our webinar next week as well, Dispensation. And just on the subject of Christmas, I was talking to Charlotte before logging on this morning. We've agreed that it's Christmas jumpers next week, so if you are joining us, please feel free to join in with Christmas jumpers as well. There might be some dealy boppers and sparkle going on, so hopefully you'll join in and have some fun with us with that. But thank you very much for registering to come along to this morning's webinar, and we're going to be looking this morning at a subject that is really close to my heart and one that I love. I'm not sure what that says about me as a person, but it's service charges and the tribunal. You will receive, following today's webinar, a set of notes. You'll be pleased to hear that there is no PowerPoint, so it's not a death by PowerPoint webinar, but there is a set of notes that Charlotte and the team at News on the Block will circulate to you following this morning's webinar so that you have those and can use them as a reference guide when you're back at the office. It's about 10-12 pages, something like that, so hopefully you will find those useful. What we're going to talk about today then, so we are going to talk about how cases get to the First Tier Tribunal, so how it happens that you end up in front of a panel at the tribunal talking about service charges. We're going to have a look at what the jurisdiction of the tribunal is in service charge matters, and what the tribunal are going to look at, what they're going to expect to look at. Have a quick look at service charges and some of the restrictions on the recovery of service charges. Because for me, a lot of points can be won if you get the basics right, and an awful lot of points can be lost if you don't get the basics right. So we'll look at some of those basics and the contractual restrictions on recovery of service charges and some of the statutory restrictions. And in particular, we're going to spend a bit of time looking at reasonableness, because if there is a bun fight in the tribunal, it is a bun fight about reasonableness. And you've all no doubt been there and had those kind of arguments and had to justify why your management fee is quite as high as what it is when you do nothing for that management fee. I jest. We'll have a look as well at case management, look at the typical kind of life cycle of a service charge case, and then also finish off by looking at Section 20C orders, because a webinar on service charge from the tribunal wouldn't be complete without a quick couple of minutes on Section 20C orders. As Charlotte has said, please feel free to put your questions through as we go, and I've got a little panel up in front of me, a little question box, so I can see those as they pop up. Probably easier to deal with them as we go than waiting till the end, so don't feel that you have to wait until the last 10 minutes to ask a question. Ask as we go and I can pick those up and deal with them. I'm not sure, normally I'm doing these things and I'm stood in front of you and I can say to you, hands up, who's been involved in tribunal proceedings, who loves the tribunal, like me, who's a little bit more cautious of tribunal. But if you have any thoughts or comments generally about your experiences in the tribunal, then by all means put them through and we can share those. Sometimes these become counselling sessions, don't they? And it feels all a bit cathartic. So let's start off then by looking at how did we end up here? How do cases end up before the tribunal when we're dealing with service charges? Well, they end up in front of the tribunal in two different ways. So there are two different routes to getting your service charge case before a tribunal. And that's either by making a direct application to the tribunal. So either you as landlord management company, RTM company, make an application either against a single leaseholder or a collective of leaseholders, or an application is made against you, management company, RTM company, by a leaseholder. So it's a direct application that's made to the tribunal, either by management company or by leaseholder. So that's the first way. The second way cases come before the tribunal is because they have been transferred, and they will have been transferred from the court. And it's section 176A of the Commonhold and Leasehold Reform Act 2002 that gives the court the power to transfer a case from the county court to the tribunal. If you haven't had a look at what section 176A says, then I encourage you to do so, particularly if you're getting a lot of cases that are being transferred from county court to tribunal. Because section 176A, and it's in your notes, is quite specific about when cases should be transferred from the court to the tribunal. And it's when there are proceedings before a court where there falls for determination a question which the FTT would have jurisdiction to answer. What I tend to find is that district judges at the county court see that it's a service charge case and go, oh, it's service charges, we must move it to the First Tier Tribunal. That's not how it should happen. The court should pass to the tribunal a question for them to consider. The question might be, are these service charges reasonable? But there has to be a question that the court needs the tribunal's assistance to answer. So as I say, two ways of getting a service charge case before the tribunal, either by direct application or transfer from the court. And transfer from the court tends to happen where you have issued an arrears claim in the county court, and as I say, the county court judge has seen its service charges, panicked and battered it across to the tribunal. Turning then to look at the jurisdiction of the tribunal. And the jurisdiction, people laugh at me when I say this a lot, but the tribunal is a creature of statute. I love saying it, creature of statute. And as a creature of statute, it derives its jurisdiction from statute, and it's section 27A of the Landlord and Tenant Act 1985. When I say the tribunal is a creature of statute, that means it can only do what statute allows it to do and what statute permits it to do. Many of you will probably have been in front of the tribunal at some point, and I tend to spend quite a bit of time when I'm dealing with tribunal cases reminding the tribunal that they are not the lease police and that they are not the accountancy police, because they seem to be invited quite a bit these days to not just be the lease police, but also to be the accountancy police. They're not. They are there to do what statute permits them to do and what statute gives them jurisdiction to do. And that jurisdiction is set down by section 27A. And section 27A says that an application can be made to the tribunal for a determination as to whether a service charge is payable, and if it is, as to the person by whom it is payable, the person to whom it is payable, the amount which is payable, the date at or by which it is payable, and the manner in which it is payable. So there are 5 elements to the tribunal's jurisdiction where we're dealing with service charges. By whom, to whom, amount, manner, and date, those 5 elements. That's what the tribunal have jurisdiction to consider. They don't have jurisdiction to consider things such as, I get it all the time, the directors have done something wrong or alleged to have done something wrong, or all sorts of other weird and wonderful queries and rabbit holes that the tribunal are sometimes invited to go down. Knack of tribunal proceedings is keeping the tribunal within what their statutory jurisdiction is. And the jurisdiction that the tribunal have under section 27A is twofold. So they have a jurisdiction to determine costs that have already been incurred, so your actuals, and they also have jurisdiction to determine costs that have yet to be incurred, so your budgeted costs. And that's really useful. This is where I think the tribunal can be your friend. That ability to get a determination on costs that have yet to be incurred can be really useful to you guys as managing agents. Think, if you will, doing a project of major works and you're going to spend £1 million of somebody else's money. Before you spend that £1 million of somebody else's money, would you sleep a little better in your beds at night, having gone to the tribunal and got a determination that that £1 million was actually recoverable as a service charge and that it was reasonable to incur costs in that way, or not? I would personally feel a little bit more comfortable if I had that determination from the tribunal telling me that those costs could be recovered via the lease as a service charge and telling me that those costs were reasonable. I float it at this point and I'll come back to it later, but using the tribunal as your friend, as a management tool, and getting those kind of predeterminations is really, really useful. And I think it should be explored more often, particularly when you're dealing with big projects of works, as many of you are at the moment in the fire safety world that we are living in. Going back to the tribunal's jurisdiction, one of the questions that I'm asked all the time is, what about if somebody has paid their service charges? Does that stop them being able to challenge them in the tribunal? The answer is probably not, unless you get some kind of estoppel argument, which is way beyond what we want to talk about this morning. But the Act is clear in that payment of a service charge doesn't prevent an application to the tribunal from being made. So somebody could be paying their service charges and yet you could still find yourselves on the receiving end of an application to the tribunal in which the tribunal are invited to determine the liability to pay and reasonableness of those service charges. However, an application can't be made where those service charges have either been admitted, so where you've got a signed admission from a lessee, or where they have been determined previously. But as I say, just because somebody pays doesn't mean that they have admitted that those service charges are reasonable and payable. Does anybody have, because no questions have come through yet, anybody have any questions on jurisdiction before we move on to the next bit? If you have any questions, then by all means put them through. So what is the tribunal, can't speak, never a good start, is it? What is the tribunal going to look at? What is the tribunal going to consider? And there's really two questions for a tribunal when they're dealing with service charge matters. The first question is the leaseholder liable to pay the sums demanded as a service charge in accordance with the terms of the lease? So that's what I call the liability issue. Is there a clause in the lease that requires the leaseholder to pay and requires them to pay for that particular head of expenditure? The second thing that the tribunal will look at is whether those costs are reasonably incurred within the meaning of section 19. And section 19 is one of the statutory restrictions on the recovery of service charges. It's where the bun fight is in a tribunal. But those are the two issues that the tribunal will look at when we're dealing with service charges. Is their liability to pay? Are the costs reasonable? And whenever you're dealing with proceedings before the tribunal, whether you are involved in taking those proceedings or whether you've got lawyers and they're looking after them for you, have in mind that those are the two issues. So when you're preparing your documents or doing witness statements, putting the supporting invoices together, whatever it might be, always have those two issues at the forefront of your mind. Is what I'm doing helping the tribunal to answer those two questions? Could I do something more or present the information in a different way that assists and helps the tribunal in answering those questions? A question that's come in, a couple of questions now. Thank you very much for putting those through. If no previous dispute was made and demands were paid with no protest, can an application to tribunal for reasonableness of costs be made? Yes, because the Act is clear in that payment of a service charge doesn't mean or isn't to be taken that a leaseholder has admitted that those sums are due, that he's liable to pay them and that they are reasonable. What you could have, if you get some clever lawyering, is that you could say that there's an estoppel argument in that somebody has been paying quite happily for the last 12 years or so and hasn't challenged, but those can be tricky arguments. For our purposes today, I would be working on the basis of just because somebody's paid doesn't mean that they've admitted the service charges, so yes, they can still make an application to the tribunal to challenge them. A question from Chris. Are there now cases that have gone before the tribunal regarding cladding, insulation, fire safety in terms of predetermination? Yeah, there's a bunch of cases that have gone to the tribunal to determine the liability to pay and reasonableness of service charges relating to cladding, insulation, fire safety, all of that kind of stuff. Pretty much most of my workload is taken up at the moment dealing with fire safety related issues and particular stuff before the tribunal. What we haven't had yet is that we haven't had any decisions from the upper tribunal. In terms of how the tribunal system works, you've got the First Tier Tribunal, who make lots of decisions on a daily basis, loads of cases go before the tribunal. And then you have above the First Tier Tribunal, the upper tribunal. You tend to go to the upper tribunal where the First Tier Tribunal get it wrong, because that's where you appeal to. Decisions of the First Tier Tribunal don't bind, and decisions of the upper tribunal do. So to have a binding authority, we need something from the upper tribunal, which we don't have yet. I suspect, Chris, that there are cases coming down the track that will deal with that, and I suspect that we will see a lot more service charge cases before the tribunal when the kind of costs that we're dealing with for fire safety matters start washing through the service charges. For example, when you start putting through the service charges, then leaseholders see how much has been spent on external wall reports and the like, EWS1 forms, that we may see some more challenges coming. Watch out for that. And on that note, if you are looking after management companies, RTM companies, please do make sure that you've got directors and officers insurance in place, and that in the event you are on the receiving end of a tribunal application, that your directors and officers insurance kicks in and provides you with defence costs cover for legal expenses. And that might be something to go back to the office and check that you do have D&O for your management companies and that it does have that kind of level of cover. I think they're the only couple of questions that's come through at the moment. So I will move on, but please do keep your questions coming through, and hopefully, Chris and Marcel, that answers the couple that you've put through there. So let's wind it back to basics and have a look at what service charges actually are. Before I do that, quick question from David. Does statute of limitation apply to historic dispute? No, the tribunal can go back as long as they want. Where limitation kicks in and where Limitation Act kicks in is in terms of enforcement. What you need to look at with your lease is to see whether your service charges are reserved as rent or not. If your service charges are reserved as rent, then for enforcement purposes, it's 6 years. If they're not reserved as rent, then because the lease is what's called a specialty, then the limitation period is 12 years. So reserved as rent, 6 years, not reserved as rent, 12 years. That matters in terms of enforcement. So if a leaseholder gets a determination that says that they're entitled to a bunch of service charges back, then they can only enforce that either 6 years or 12 years, depending on how many service charges are reserved, even though the determination might go beyond that. Hopefully that makes sense. No other questions? Let's look at then what a service charge is. And a service charge is defined by Section 18 of the 1985 Act. Your leasers will call them all sorts of other names. You'll have seen them called building charges, estate charges, apartment charges, maintenance contributions, all sorts of other different names and different labels. Matters not a jot, because for the purposes of Section 18 and in law, these are service charges. Call them what you want. They're still a service charge in law. And a service charge is defined by Section 18, like I say, of the 1985 Act as an amount payable by a tenant of a dwelling as part of or in addition to the rent, which is payable directly or indirectly for services, repairs, maintenance, improvements, if your lease allows, or insurance, or landlord's cost of management, and the whole or part of which varies or may vary according to the relevant costs. So it has to vary. It can't just be a fixed percentage year on year on year, which is what happened in our Alton Britain. Couple of points to make in relation to that Section 18 definition. It talked about payment of costs to a landlord. A landlord for these purposes isn't just the person that collects ground rent, but is, under the 1985 Act, the person who has the right to enforce payment of a service charge. So that could be your RMC and could be your RTM company. Helpfully, landlord isn't defined in the same way in different statute. Thank you, Parliament, when you drafted it. But for our purposes, service charges, 85 Act, landlord is the person that would enforce payment of a service charge. The notes that you will get cover all of this off and cover off what I was saying about cost varying and relevant costs as well. So that's what a service charge is. Let's put that into a bit of context in terms of how the tribunal are going to approach service charges and approach your application when you're sat in front of them. And the first thing that they're going to do is it's a bit of a mechanical process. And I think that you can do yourselves a massive favour and start getting yourselves ready now for any tribunal challenges that might be coming down the line. You're in the midst of budget season, if you haven't already been doing your budgets. And one of the things that I think you should be doing and that every agent should be doing when you're dealing with budgets is have your budget in one hand or on one screen of your computer. If you're old like me, you will have printed it off because I'm old. You will have your lease in your other hand. Again, some of you that are younger than me might have it on a screen. I like it printed in front of me. Again, I'm old. So budget in one hand, lease in the other. And what you're looking for there is you're looking at each line item on your budget, and you're then comparing that with your lease to ensure that there's a clause in the lease that allows you to recover that specific cost. You might say in your budget, we intend to spend £10,000 on gardening. Is there a clause in your lease that entitles you and enables you to recover those gardening costs as a service charge? Hopefully, yes. Write it on your budget so that you've got that reference there for next year. You intend to do some window cleaning and intend to recover the cost via the service charge. Again, look at your lease. Where's the clause that entitles you to recover those window cleaning costs? Then you're comfortable that you can recover them. Because what you can't do is that you can't go and spend a load of money and expect to recover it by the service charge if your lease doesn't permit it. If your lease doesn't allow you to recover the cost of window cleaning, then you can't, forgive the pun, wash it through the service charges. You can only put through the service charges what your lease permits. Better to know now before you go and spend somebody else's money, and better to do it as part of that budget exercise. Then it's there. It's there for when the inevitable happens, that you end up challenged at a tribunal. Because the tribunal, when you're sat in front of them, will expect you to take them to the lease and expect you to take them to the specific clauses that enable you to recover via the service charge these heads of expenditure. It's a mechanical process. It's not a very interesting process, I have to say, much as I love my job, but it's one that needs to be done. So pass that to one of your colleagues if you don't want to do it yourself. But it's important that you do that and that you're comfortable the costs that you are seeking to recover are actually recoverable as service charges. There are some more questions. Let me. Sorry, guys, I am just trying to get rid of the ones that I've answered so I can see all the rest of them. Alan says, I have a leaseholder counterclaiming in court against agency after we sent him to debt collection for arrears. Do you come across this much? Yeah. It's happening with a bit more frequency than it used to happen with. And I'm not sure whether you're finding as well as a general point that when you are sending people for recovery action, that you're getting more defences now than you ever used to get. But yes, I am finding, Alan, in answer to your question, that leaseholders are filing counterclaims, and the counterclaims tend to be for disrepair type issues more often than not. So they will say, I haven't paid my £1,000 service charges because you haven't kept the property in a good and substantial state of repair. And because you failed to keep it in a state of repair, I've had water leaks and I've not been able to let out my property for the last 12 months, so I'm counterclaiming for loss of rent or whatever it may be. Watch out for those. If you do expect that your leaseholders will counterclaim, then please tell your lawyers at the point that you send the instruction across so that they know about it. Linda says, I manage a mixed estate with variable estate charges payable by houses and flats. Does the tribunal have jurisdiction for reasonableness of estate charges for non-leasehold properties? No. It is a brutal world out there for people who pay a variable estate service charge. And it's one of my soapbox things that it is really brutal. If you are a lessee of a leasehold property, you have a raft of protections. If you are a freehold owner of a house who pays a variable estate charge for the golf course or whatever it might be, then you don't have those protections. And so you aren't, in answer to your question, Linda, able to go to the tribunal to challenge those. That, I think, answers your question as well, David. A couple of questions come in relation to that. Chris, I'll come back to you in a minute in relation to yours and yours, Graham. So let's have a look at what the restrictions on recovery of service charges are. They are contractual and they are statutory. And if you get it wrong, then the service charges aren't payable. In some cases, I can correct it because that's my job. In other cases, if you get it wrong and you don't realise quickly enough that you've got it wrong, then I can't correct it and those service charges become stale and unrecoverable. So it's really important that you're aware of what the contractual restrictions are and aware of what the statutory restrictions are, because tribunal's going to ask you and will expect you to have complied with both contractual and statutory. Woe betide if you haven't. So contractual restrictions are lease specific. They're based on the lease. And we all know that leases differ from block to block to block. I'm getting old, and I remember standing on stages 10 years ago saying to people, for each estate you manage, you need to make sure that you've got a lease and that you've read it, understood it and implemented it. And people would go, oh, really? You don't do that now. Most agents are, you've got leases for the blocks that you're managing, you have read them, you've understood them and you've implemented them. And this is what the contractual restrictions is getting at. So you need to make sure that you are looking at the lease and seeing what the lease says in relation to service charges. Does it actually provide for a service charge to be paid? You need to make sure that you are demanding in accordance with the lease. Watch out if you have a crap lease where lawyers haven't been able to add up to 100 and you've got like 70% recovery and a 30% shortfall. You can only demand in accordance with what the lease says. So if the lease says each leaseholder pays 2.5% and that adds up to 80, not 100, you've got an under recovery. Go to the tribunal and vary your lease in those circumstances. And it's section 35 of the 87 Act that would allow you to do that. From a contract point of view, you can only demand, as I say, in accordance with the lease. Tribunal will look at how you've been demanding and if you've been demanding on the correct dates, in the correct kind of way, and that you have complied with the contractual preconditions. I tend to find if people fall down, it's that bit that they will fall down on. And there is a cautionary tale from the Court of Appeal. It's a couple of years old now, and it's the case of Skelton and DBS Homes Kings Hill Limited. If you haven't read about that case, then go and have a read. There's all sorts of blogs on the internet about it. And it's a cautionary tale. And what happened in Skelton is that there was a lease, and the lease set out various preconditions. And these preconditions are precursors to payment. You have to satisfy those preconditions before the service charge liability is triggered. And the precondition in Skelton was pretty common in that it said when you're demanding service charges, you have to have prepared a budget, and the demand that you send out has to be accompanied by that budget. Really simple precondition. What the landlord in Skelton had done is that he had been preparing his budgets, fine, and he had been sending out his service charge demands. What he'd not done is put the two things in the same envelope and send them together. So although a budget had been prepared, it had never been sent with the service charge demand. So the Court of Appeal said, well, that doesn't comply with the preconditions in the lease. So those service charge demands that you've sent back in 2012, 13, 14 aren't actually payable because you didn't comply with those conditions precedent. And beyond that, the 18-month rule, so section 20B, 18-month rule that we all know and love, applies to on-account demands. So none of those service charges that you have sought to demand over the last 4 or 5 years are actually payable, and now they're all stale as well. So the landlord ended up with a black hole, and I think it was a black hole to the tune of about 480 grand, because they've not looked at the lease and understood and implemented the lease in terms of complying with those preconditions. So please, if you take nothing else away from this webinar today, take this away, in that you go back and you look at your leases and you see if there are any preconditions and you comply with those preconditions, because if you don't, you're going to end up with stale service charges. And stale service charges are unrecoverable. And who do you think the management company directors are going to look to if they end up with a bunch of stale service charges? Probably you guys as managing agents, and you're probably dusting off your insurance certificates at that point. Even if your precondition is something ridiculous, and I tend to give the example at this point of, you know, it says your service charges must be demanded on pink paper with purple spots, then go and buy pink paper with purple spots and make sure that you're demanding your service charges on pink paper with purple spots, because if you don't, they're not payable. And like I say, the consequences of that are severe. Don't fall foul of those contractual preconditions. Make sure you're complying with them. We'll move on to have a look at, conscious that there's some more questions come through. I will come to those. Thank you for putting them through. Keep them coming. I'll have a look at the statutory restrictions on recovery of service charges. These apply across the board. They're not lease specific. And I anticipate that you have mechanisms in place at your organisations that will deal with these. So we'll whip through some of them. The first one is that any demand for service charges has to identify the landlord. So has to give name and address of landlord and an address in England and Wales for service of notices, including notices in proceedings. Please make sure that your service charge demands have that information. If you're acting for an RTM company, which some of you may be, or you in fact may be RTM companies, then for the purposes of sections 47 and 48, it's your details that go on there. Because you've acquired the right to manage, you've stepped into the shoes of the landlord for those purposes. Has to be a service address in England and Wales as well, please. Please. Please make sure as well, when you are sending your service charge demand, that you send a summary of rights and obligations with it. And please make sure, and for those of you in England, that you are using the, I say up to date, they got updated 7.5 years ago. Still some of you are using the wrong version. But please do make sure that you are using the up-to-date version, which came out on the 1st of July 2013. You will notice the difference because one refers to, I think the old version refers to LVT and vexatious cost limit of 500 quid. So if your rights and norms refer to that, then you know you've got the old version. When you are demanding service charges, you have to enclose a copy of the summary of rights and obligations for service charges. If you happen to be demanding administration charges, there's a separate set of rights and obs for admin charges. If your demand is a mixed demand, so covers both service charges and admin charges, so both sets of rights and obs. When you are putting your bundle together for the tribunal, it's a good idea to, I say it's a good idea, it's a must to include within that bundle the rights and obs that you have served with your demands, so that the tribunal can see that you've satisfied section 21B. You then have as your next statutory restriction the 18-month rule, and that's section 20B. There is a case coming to the Court of Appeal, it's going to be into next year now, which deals with the 18-month rule. Every so often we get a new case on the 18-month rule, which makes the whole situation a bit more clearer than mud. But for our purposes this morning, section 20B, 18-month rule, says that a landlord within 18 months of incurring a cost must either demand it as a service charge or serve a notice on the leaseholder in writing telling them that these costs have been incurred and that they will be required to contribute to them by means of payment of a service charge. So you have two things that you need to do once you've incurred costs or started incurring costs. Either demand them as a service charge, or if for whatever reason you can't get your demand out, maybe it's a balance in demand and you're waiting for accounting information, whatever, serve a section 20B2 notice. Stop that 18-month clock. The notes that you will get go into a bit more detail about section 20B2 notices. I don't know whether any of you guys adopt those as a practice. Some agents do. The next statutory restriction is consultation. So if when you are before the tribunal dealing with your service charge application, you have undertaken project of qualifying works, or there is a QLTA lurking somewhere, then the tribunal will expect you to have either undertaken consultation, in accordance with the 2003, 2004 regs, depending on whether you are in England and Wales, or the tribunal will expect you to have gone to it and asked for dispensation from consultation. If you haven't consulted or haven't gone and got dispensation, then the service charges you can recover are capped, and they will be capped at 250 quid per leaseholder if it's qualifying works, or £100 per leaseholder per financial period if it's a QLTA. Watch out for hidden QLTAs. You're really good at spotting when it works and you need to consult. What I tend to find people get caught out with are these kind of hidden QLTAs that you hadn't realised were a QLTA. So a QLTA, qualifying long-term agreement, is an agreement entered into for more than 12 months or for a term of more than 12 months. You're pretty good these days with your management agreements. It's not those that I'm talking about, but it's things like your maintenance contracts. They might be for longer than a year. Sometimes your insurance runs for longer than a year because you've had to get an extended period. Like I say, lift maintenance, ongoing other types of maintenance. Just have a look at those and make sure that you haven't accidentally tripped into QLTA territory. Utilities is another one as well that I see from time to time that is a QLTA. And what will happen is that if you have, I don't know, spent 120 quid on a contract per leaseholder per financial period, and you haven't consulted, is that the tribunal will just knock 20 quid off, knock it down to 100 quid. That's the practical effect of it. Some more questions coming through. I'll come to those. Let's look at where the bun fight is at the tribunal, and it's all about reasonableness. And this is where, when you're dealing with unrepresented leaseholders, they will get really confused because they don't understand quite how the tribunal will approach reasonableness. And so far as reasonableness is concerned, the tribunals are looking at the decisions that have been taken by landlords to incur costs and whether the costs are therefore reasonably incurred. And they'll also look at, it's what's called the value for money test. How much bang are you getting for your buck? If you're paying 200 quid a month to the window cleaner, is that for an hour's work or is that for 10 hours work? What are you getting for what you're paying? So when you're presenting stuff to the tribunal, have that in mind. Have in mind being able to demonstrate to them, this is why we incurred a cost in this way. This was our rationale. This is why we did it. This is why we chose to landscape the communal gardens. This is why we went to Fred to landscape the communal gardens. And this is all the stuff that we got for spending 20 grand on Fred landscaping the communal gardens. Show them why and show them what you've got for it. That's what they're looking for. And the tribunal will review what you've done and review the decision that you've made. The tribunal might come to it, or phrase that slightly differently. Had the tribunal been making the decision itself, then they might have come to a different decision. Had the leaseholder been making the decision himself, he might have decided something differently. But that doesn't matter. What matters is the decision that was made by the landlord and whether the decision made by the landlord falls within what we call a range of reasonableness. If it falls within that range of reasonableness, then it's a decision that has been reasonably taken. The costs incurred are reasonably incurred as a result of that. So, like I say, going back to what I was saying, be able to demonstrate to the tribunal why you've chosen to incur costs and why you've chosen to incur them in that particular way, and what bang you're getting for your buck, what you're getting for that money that you have spent out. I have set out in the notes that you'll receive a quote, and it's a quote from a case that we lawyers say all the time in the tribunal, and it's Regent Management and Jones. And that talks about this test for service charge that was made was a reasonable one. And it says, the test is whether the service charge that was made was a reasonable one, not whether there were other possible ways of charging that might have been thought better or more reasonable. There may be several different ways of dealing with a particular problem of management. All of them may be perfectly reasonable. I nick Justin Bates's phrase at this point and say reasonable people can reasonably disagree. Each of them may have its own advantages and disadvantages. Some people may favour one set of advantages and disadvantages, others another. And the tribunal may have its own view. If the choice had been left to the tribunal, it might not have chosen what the management company chose, but that doesn't make what the management company chose unreasonable. And that's what it says in Regent Management and Jones. It doesn't matter that they can wander off and get it cheaper elsewhere. What matters is the rationale that went behind landlord management company's decision to incur costs in that particular way. So whenever you're putting anything together for the tribunal, have that at the forefront of your mind. Let's have a look at some of the questions that have come through. Chris, does there have to be a landlord and tenant relationship between the parties? What about charges that are levied in connection with access rights? Ooh, probably an offline one to talk about, Chris. Happy to give me a shout on that one. Graham says, how does the tribunal look at sweeper clauses if those elements of work are not specified in other clauses? The tribunal's taken a bit more of a generous approach recently to sweeper clauses, and a really good example of that is the Chiswick Village case from about 18 months or so ago, and that was all to do with AGM costs and advice in relation to AGM and D&O insurance. And the tribunal really set out this generous approach that they recognised a company has to function, and because if the company doesn't function, it can't provide all these services, and it needs to get advice, and nobody's going to volunteer to be a director if there isn't D&O insurance in place. And it therefore allowed those kind of costs to be recovered via the service charge, even though the clause wasn't the greatest, and it was a proper sweeper clause. So in answer to your question, Graham, it's a bit more of a generous view that's being taken these days than has historically been the case. Anonymous attendee, would a statement of estimated cost be sufficient, or do you need your actual budget spreadsheet? I'm not sure what that was in relation to. If you want to type it back through and give me a bit more context, and then I can help you with that one. Another one, how do you think tribunals are going to handle hearings in 2021? Will they still be online via Zoom, or will they go back to normality? Normality and tribunal in the same sentence. Smiling. It's been a tricky year for the tribunal, and it's been an even trickier few months because half of the judges have been nicked and moved across to the county court because of the embargo on possession proceedings that we had until September. They've taken a bit of time to get to grips with how to deal with hearings. And they have been using, over the summer months, a variety of different platforms. They've now developed their own platform. It's got some teething problems. I had a hearing on Tuesday and dialed in for my hearing half an hour before I should have done, and to be told that no tribunal hearings had run that morning because the whole system had crashed. So to dial in an hour later. When it works, it seems to work very well. I can say that I don't mind remote hearings at all, but there are teething problems, as I say, with the tech. The tribunal is still finding its feet, but it's getting better, which is the positive thing. Will hearings continue online? I suspect for the foreseeable that they will. That's certainly when I'm dealing with setting down cases for hearings, we're still working on the basis that there'll be remote hearings. I quite like remote hearings. I quite like going to court in my slippers. I had a case in the Court of Appeal in the summer, and it was brilliant to tweet that I'd gone to the Court of Appeal in my slippers. I don't know what everybody else's experience of the remote hearings is. I'm not a fan of telephone hearings, but video hearings I'm fine with. Any more questions, please do keep them coming through. I wanted to talk to you just in the last few minutes in relation to case management and procedure, and give you a kind of oversight as to how a typical case runs through the tribunal. And if you're in England, then the tribunal's rules are the First Tier Tribunal, the Tribunal Procedure First Tier Tribunal Property Chamber rules of 2013. It's in the notes, don't worry. And they govern how the tribunal behaves and how it deals with cases, how it deals with applications, how it deals with case management generally. If you're dealing with tribunal stuff yourself rather than lawyering it out, then get yourself a copy of the rules, because you're going to need them and you'll need to refer the tribunal to them. In really basic terms, how this works is that an application is made to the tribunal, and the application form, there are specific application forms for whatever you're applying for. So there's a specific application form for service charges. And in that application form, it asks for various documents to be provided, copy of the lease, that kind of thing. So the first thing that happens is an application's made with accompanying documents. What's likely to happen then is that the tribunal will get hold of that application. They're being made online at the moment. You can email the tribunal, and they will then copy it to all of the parties. So the first thing you might know about it is when it lands on your desk or lands in your inbox. What will happen then is that a case officer, like I say, judges have been nicked for the moment, or a lot of judges have been nicked. A case officer will probably have a look at your application and will issue some directions. Let's work on the assumption that it's not a complicated case and that it doesn't need a case management hearing. Those directions are going to set out a timetable, and they'll set out a timetable for the case and the progression of the case through the tribunal up to and including the final hearing. And it will give people certain things to do by certain dates. Directions are pretty specific. And the directions are going to require applicant to set out why they're going to the tribunal, what it's all about. And they're going to require the applicant to serve documentation as well. Let's work on the basis you're the applicant. It's going to be things like accounts, budget, demands, statement of accounts, section 20 documents, if that's included, supporting invoices, all of that kind of shebang. And they're likely to want a Scott schedule, so sets out heads of expenditure, what's challenged, why it's challenged, and comments from both sides. The directions are going to give the leaseholder an opportunity to respond, set out their position, and also serve any documentation, so those like-for-like comparative quotes. You'll probably get an opportunity to respond to what the leaseholder says, so to file an additional statement of case. You're then going to have to prepare the bundle. Please make sure it's paginated and looks pretty. You will win so many favours with the tribunal if they have a bundle that they can negotiate and move around rather than just papers flying everywhere. Those bundles will be lodged, and then you will have a final determination that will either be on the papers or it will be at a hearing. There's more stuff being dealt with on the papers at the moment for obvious reasons, and hearings are being dealt with remotely, so you can go to a hearing in your slippers at the minute. You're not going to get a determination on the day. Your determination is going to be sent to you in the post up to 8 weeks later. The quickest I've ever had one is a day. Normally it's somewhere around 4 to 6, if not 8 weeks. So it's a while before it actually lands on your desk. I'm conscious that we have 5 minutes left, and I can see that Charlotte's come back on.
I have, yes. We'll have to sort of round up now. So do you want to ask any other questions that you've got? I think there might be one new one. at the bottom.
Let me have a look. When sending service charges out, you said your budget must be sent along with the invoice. I can't scroll down to that one. Let me just. Once the budget is loaded, we create a statement of service charges which outlines each item of expenditure. Is this okay? I don't know, because you'll need to have a look at what your lease says. So I can't tell you without looking at your lease. What you need to do is to go back to the office, get your lease out, see what your lease says that you need to do and what information you need to give to the leaseholder before that obligation to pay service charges is triggered. Once you understand what your lease says, compare that to what you're doing, and you'll then be able to be satisfied or not that what you're doing accords with the lease. If it doesn't accord with the lease, then change your procedure, because if you don't, you're going to end up with a stale bunch of service charges. Hopefully that helps.
Oh, that's brilliant. Well, Cass, thank you so much. I'm sorry we've got to finish now, and I'm sure there's loads of other questions and stuff, but as we said, we'll be sending all the notes through to everybody who's attended. And if you are enjoying Cass's advice, she's going to be back on Tuesday at 10 o'clock. We're going to be talking about dispensation from consultation. So please go to our website and register. And we'll be delighted to see you. And I think we'll keep the same format, Cass, if you're happy with that.
Absolutely. And don't forget your Christmas jumpers.
Yeah, and don't forget your Christmas jumpers. Yes, I'm feeling under pressure now to go and get a new one. Well, look, have a great rest of the day. And Cass, thank you very much indeed for taking the time to join us today. It's been great.
You're welcome. Thank you. Thank you, everybody.
Bye-bye. Thanks very much.